Hadley joins me today. He's a partner in the Insolvency and Litigation team at Holman Webb. Hi, Chris.
Hi, Adriana.
So the government, right off the bat, introduced some relief measures in terms of the insolvency and bankruptcy space. In terms of your experience and your dealings with all the liquidators, have you seen a surge in bankruptcies and insolvencies since COVID-19?
Look, the short answer is no, there hasn't been a surge. And I can say that from two main bases. Number one is, anecdotally, in my dealings with liquidators and trustees, they have indicated that there hasn't been an influx over the last 2 months. And that's been the general consensus in my discussions with liquidators and trustees. The weekly insolvency statistics published by ASIC and AFSA have indicated that in March and April of 2020, there's actually been a significant drop and a downward trend in such appointments as against same time last year. That's not to say that this will continue. My view is that it almost certainly won't continue. Following end of financial year and into September, October, and into the next year, I think there's going to be an increase in insolvency appointments, and I think that's a view that's shared pretty widely in the insolvency world.
Okay, so if you're working specifically in the credit function, what are we looking at in terms of statutory demands? I know there's been quite a bit of change there.
There has. As part of the impacts of COVID on the economy, the federal government introduced temporary changes to the rules affecting statutory demands, and they are quite significant changes, and they've changed the, I guess, the utility of issuing statutory demands at this point in time.
So originally, what were we looking at with statutory demands? Was it 21 days?
So the position with statutory demands prior to these temporary changes is that a creditor who was owed in excess of $2,000 could issue a statutory demand on a debtor company. And upon issuing that demand, the debtor company had a period of 21 days to comply with the demand. If the debtor company did not comply with the demand, i.e. paid the debt or came to an arrangement to the creditor's satisfaction, that debtor company would be deemed to be insolvent for the purposes of the Corporations Act, and the creditor could then make an application to the court to appoint a liquidator to the debtor company. As a result of the temporary changes to the rules affecting statutory demands, the threshold debt has increased from $2,000 to $20,000, and the time period for compliance with the statutory demand has increased from 21 days to 6 months.
Okay. So, Chris, does this all circumvent the Corporations Act? And if so, for how long?
Look, I mean, it does insofar as it impacts the ability of a creditor to issue a statutory demand under the Corporations Act. It certainly has changed the rules. Now, the good news is, or the bad news is, depending on which side of the fence you sit on, in terms of maybe if you're issuing one or receiving one, the changes are scheduled to expire on 25 September of this year.
Okay, so where does this all leave directors and their liability?
As part of these temporary measures, the government announced that in an effort to make sure that companies have confidence to continue to trade through the coronavirus period, with the aim of returning to viability when the crisis passes, directors will be temporarily relieved of their duty to prevent insolvent trading with respect to any debts incurred in the ordinary course of the company's business. The net effect of this is that directors are relieved of personal liability that would ordinarily or otherwise be associated with insolvent trading. There are some exceptions to this relief. For example, it doesn't cover instances of fraud or dishonesty on the part of the directors, and it does not change the ultimate liability of the company to pay its debts. But the changes are quite significant because ordinarily, when a director may be concerned about the company being insolvent, may prompt him or her to appoint a liquidator so as to avoid potential personal liability. That position is now not in place, and the director may take the view that rather than pulling the trigger on appointing a liquidator now, he or she may wait until a number of months have passed before making that decision. And I think that change may have also influenced the number of appointments of liquidators at this point in time. So again, it's a temporary measure, and once that reverts back to the old position, I suspect there will be an increase in the numbers of appointments.
Thanks for your time today, Chris.
Thanks so much. Appreciate it.